On the 7th of July 2005, four young British-born Muslim men entered the London Underground system carrying bombs. They were driven by political grievances, both real and imaginary, and inspired by a fundamentalist religious dogma, and puffed up with arrogance and self-delusion. They wanted their place in history. And they were to take their own lives that day and those of 52 ordinary members of the public going about their business on the London Underground and on a bus. And in addition, they seriously injured about 600 other people. And you'll remember, even as I say those words by way of introduction, the scenes of carnage, some of which were available on the television and so on. And you'll all remember the iconic photograph of a London bus, 38 bus, with the top ripped off it. That for us is an image which pretty much defines a generation in the same way as the Blitz and the Battle of Britain had for our parents and grandparents. And it's had a very far-reaching effect, because those bombings in London brought the threat of sudden and violent and unexpected death to everybody in the country going about their ordinary life. This wasn't in some dusty, far-away, foreign place that we needn't worry about, thousands of miles away, but in a familiar town in this country. And it's a threat which has changed the language of politics, and it's a threat which has changed the political landscape, because our political leaders told us then that these events were no mere crimes. They were not to be seen as the isolated acts of a few fanatics. These were orchestrated plans of a worldwide conspiracy to wage war against us all, against democracy and against freedom, was the sort of language we heard from our politicians. They were attacks mounted against everything we hold dear. The very fabric of our society was being threatened, it was suggested. All of our institutions, all of our values. And you remember that there was talk of global war. From our point of view, a global war on terror is the sort of language that was used. And that language will be familiar to all of you, because it was pretty rare to switch on the radio or a television following the bombings without hearing that sort of rhetoric, or to open a newspaper without being overwhelmed by that sort of language. There came a time, because of course this followed on from 9/11 in 2001, where every political event in the world was to be viewed through that sort of prism, the global war on terror. And the actions of each and every country throughout the world were to be judged in relation to it. And the rhetoric was this, wasn't it? You're either with us or you're against us. You're either with, as it were, the West, liberal democracy, or you're against us. And it was a very simplistic worldview, looking back on it now, some years later. A very simple worldview, whichever side of the line you fell on, because the rhetoric went both ways. The rhetoric of crusade and counter-crusade. Because this was seen or billed as an extraordinary threat to our democracy and the state, it called for extraordinary measures to meet that threat. If you look at the United States example following the 9/11 Twin Towers attacks, it was famously said that the rules of the whole game have now changed. And that wasn't said by the American president, it was said by our own Prime Minister, and a lawyer at that. The rules of the game have now changed. And the extraordinary measures that were called for following that event included not only the military attack on Afghanistan to capture or to kill those said to be responsible, but also a whole list of other things, the impact of which is only now being seen a decade afterwards. A refusal to treat captured combatants as prisoners of war under the terms of the Geneva Convention. The extraordinary rendition of detainees to third-party countries where the conditions of their detention and interrogation could be kept secret because those who were responsible for their rendition did not want the world to know how they were being interrogated in those secret locations. They did not want the world to know that they were employing torture and cruel and unusual treatment by means of things like waterboarding, sleep deprivation, isolation, and the like. Detention without trial, indefinitely, in places like Guantanamo Bay, outside of the jurisdiction of the American courts, and out of the reach of domestic human rights protections in the United States, followed by the proposed trial of people seized and rendered in that way in secret by military tribunals with lawyers from the military appointed to defend them, and so on. And this was a catalogue of officially sanctioned conduct representing, in the judgment of many lawyers at any rate, a complete abandonment of the rule of law in response to awful circumstances, but a wholly unnecessary and excessive and disproportionate response. And following our own 9/11 in July of 2005, there was a significant risk in this country that our own political leaders would take us down pretty much the same route. That was what many of us feared. And it wasn't for want of trying on the part of some of our politicians, and we have our own list of shameful things that were proposed and fought for, contended for by our politicians. An attempt to extend pre-charge detention in terrorism cases to 90 days without charge. An attempt to sustain a system of indefinite administrative detention of people thought by the Secretary of State to represent a terrorist threat. Indefinite detention without charge or trial. And when that failed, control orders. Control orders based, imposed on the basis of undisclosed allegations and intelligence and evidence shown only to the judge and not to the accused or to his or her lawyers. Now, compared with the history of what happened in America, this is a relatively modest list of attempts to change the rules of the game. But they were significant attempts, nevertheless, and made in a jurisdiction which is proud of the claim to have taught most of the world the importance of the rule of law, and to have, in effect, helped to create due process as a core legal concept, and to have largely authored the European Convention on Human Rights. This is the country which produced propositions like those I've just described. But fortunately, the key word to note is attempt, because each of those developments in turn was defeated or simply collapsed in on itself as a result of legal challenges mounted against them by way of judicial review and by way of appeals to the higher courts. So that, for example, administrative detention on national security grounds of foreign nationals, which was the starting point, let's just lock people up if they're foreigners, if the Secretary of State says that they pose some sort of threat to us, was defeated by the House of Lords in 2005 on the basis that detention without trial or the prospect of deportation for such people simply drove a coach and horses through their rights under the European legislation and our own Human Rights Act. Because, amongst other things, such detention was ordered by the Home Secretary on the basis of secret evidence and was unlimited in time. And the House of Lords decided that that sort of detention was not simply unfair, but it was discriminatory because it applied only to foreigners. And that decision by the House of Lords, you may remember, some of you, caused apoplexy on the part of senior Labour Party politicians at the time, and a great deal of ill-judged public condemnation of the judiciary, who were said to be soft on terror, it was said at the time. It led to the introduction in 2005 of control orders by which the Home Secretary could not just round up the foreigners, but could also order British citizens who could not be deported, in effect to be held under house arrest under very rigid and draconian conditions. And by including British subjects, the government believed it could avoid the accusation of being discriminatory. So it was no longer discriminatory, it was just in breach of human rights standards on anyone's view. And what's quite interesting was that although the conditions were acknowledged by one and all to be draconian, they were justified as a result of the what was constantly described as the imminent risk to national security. The constant reply of politicians is this imminent risk. And you remember the claims of the then Home Secretary, Charles Clarke, who described it as a public emergency threatening the life of the nation. You'll have seen very recently, for example, with the recent bail conditions imposed on Abu Qatada, the sort of conditions which were then regularly imposed under that regime, powers exercised to effectively prevent a person subject to a control order from having a normal life or any sort of life at all, because the conditions applied under the order, including home curfews amounting in effect to house arrest. You'd be let out of your house for an hour or two each day and followed down the road to Tesco's by MI5 or the police or both. Strict limits on who you can meet or communicate with. Denied the use of a telephone except the landline in your house, which is constantly monitored by the security services. Loss of your passport or any other travel document, so you can't leave. Being banned from public transport, so you can't get on a bus, go anywhere. And electronic tagging. And all of those things on the basis of secret evidence that you're not told about and without limit of time. So evidence and intelligence not disclosed to you or to your lawyer, and therefore incapable of any form of effective challenge in the courts, imposing on you a life sentence, in effect, not in a prison, but in a sort of prison, a life sentence on secret evidence, with no prospect of appeal and no due process. And we imposed that regime on 45 individuals over time. And then we were surprised when the Muslim community in this country was outraged and thought that they were being picked on and discriminated against. We were surprised by that. However, strong principled objections to that sort of removal of liberty continued, and in particular, in a whole series of really important judgments, the House of Lords, now the Supreme Court, made significant inroads into the practice of control orders to the point at which they had, in effect, to be abandoned by government as a mechanism. The judges limited the time that someone could be forced to remain in the home each day to 16 hours, as opposed to 22 or 23 hours. And crucially, in a case called AE and AF in 2009, the House of Lords set out strict limits on the extent to which secret evidence, undisclosed to the defence, could be used to justify the imposition of such orders. And that followed important rulings to a like effect in the European Court of Human Rights, both of which took the view that in some cases detainees had been denied a fair hearing or any real hearing at all because they hadn't even been told the gist of the case against them. And as Lord Phillips, not exactly a sort of trembling, weak-kneed liberal, said, a trial procedure can never be considered fair if a party to it is kept in ignorance of the case against him. If the wider public are to have confidence in the justice system, they need to be able to see that justice is done, rather than being asked to take it on trust. And his colleague Lord Hope said this: consequences of a successful terrorist attack are likely to be so appalling that there is an understandable wish to support the system that keeps those who are considered to be the most dangerous out of circulation for as long as possible. But the slow creep of complacency must be resisted. If the rule of law is to mean anything, it is in cases such as these that the courts must stand by principle. It must insist that the person affected be told what is alleged against him. Now, following that judgment, in pretty trenchant terms, a number of the orders were immediately reviewed, and in the majority of cases they were simply discontinued, rather than wash the dirty linen in public, as it were, tell these accused what the case was against them. The control orders were simply dropped. Well, we now have what lawyers call control orders light under the Terrorism Prevention and Investigation Measures Act 2011. This again is described as a new regime to protect the public from terrorism. And the measures which came into force in December permits the Secretary of State to impose measures on an individual who is, and I quote from the statute, reasonably believed to be or has been involved in terrorism-related activity. It's a pretty broad brush that's being used here. Reasonably believed that he is or has been involved in terrorism-related activity. Well, that might involve the possession of a copy of Inspire magazine published on the internet. It tells you how to make a bomb in the kitchen of, in your mum's kitchen, I think the article is called. You download that onto your computer, and any of you, and you have engaged in terrorism-related activity and might be made subject to an order such as this. The measures again include conditions relating to overnight residence, travel, exclusion from a particular geographical area, financial services, can't have a bank account, can't have a cash card, property, not allowed to buy property, presumably rent it, I don't know. Electronic communication devices, not allowed a phone or a laptop or an iPad or anything of that sort. Association, not allowed to go down to the mosque and see your friends or your relatives without permission. Reporting twice a day at your local police station. Photography and monitoring. So a whole range, once again, of pretty draconian measures which remain in force for a year and may then be extended again. So now subject to review annually, but may persist potentially indefinitely. And whilst there is supervision of this executive power by the High Court, the court is only allowed to reject measures imposed or proposed by the Secretary of State, where the decision about the need for such measures is, and again I quote from the statute, obviously flawed. So it's imposing the sort of test you get in judicial review proceedings, which the lawyers amongst you will know, is a pretty stringent test. You have to demonstrate that the Secretary of State has lost his marbles, basically, in making such an order, and no reasonable Secretary of State could possibly, under any circumstances, have made such an order as this. That's the kind of threshold to challenge the imposition of such measures. And in some cases, when the Secretary of State considers that it is urgent, Abu Qatada would probably be an example of someone in different circumstances, then the measures are simply directed by the Secretary of State, who then refers the case to the court for ex post facto ratification. And by statute, if the High Court gets this wrong, by statute there is no appeal from the decision of the High Court in support of the Secretary of State's exercise of executive power. And if measures are imposed and then breached because you're told you may not associate with, I don't know, a list of people who are your friends, and one of them rings you up or comes and knocks on the door, or you bump into them in the street, you can then be liable to imprisonment for breach of the measures up to 5 years. And under the old control order regime, people were regularly busted. It wasn't an idle threat. People were regularly given prison terms for breach of control orders. And so one expects that that will happen in the future with these. And again, it's worth just pausing and reflecting on the situation here, because this is imposing the liability to imprisonment on the subject of an administrative order who has committed no offence, and has never had the evidence of their involvement subjected to an informed challenge through the courts. And of course, when the Secretary of State applies for such an order, he's applying for an order not against a person who can be proved by evidence to have committed an offence or planned a terrorism attack or done any of the things under the various pieces of counter-terrorist legislation. But this is a person against whom there is no admissible evidence that can be placed before a court to show that they're guilty of anything. And again, it is all justified on the basis of a perceived threat to national security. And those things have to be approached with a great deal of caution and rationality. These are individuals not told of the evidence or of the intelligence that the minister and potentially the court sees, no opportunity to challenge or contradict it. And although the measures represent a marginal improvement on the control order regime because the measures are a bit less harsh, it's really a modest improvement on the old regime. And so we are still not out of the woods. But again, the point I'd invite you to take is that by applying human rights standards of fairness and transparency, a brake of sorts has been put on the ability of our government to damage the human rights network of protection by pleading national emergency, national security, protection of the public from terrorism. The courts look at these things quite carefully. And it's a very interesting, I occasionally ponder on why we should, in this jurisdiction, have been much more successful and much more vocal in protecting these rights and guarding against these encroachments than has been the case in America. I simply don't know what the answer to that is. And another area of real interest relates to trials for terrorist offences. This is of really crucial importance, because we have at least maintained the stance that terrorism acts committed both here and abroad are just that. They're crimes, horrific crimes for the most part, but no more than crimes. And you don't need to take that from me, because speaking of the 9/11 attack, no less a figure than Eliza Manningham Buller, then Director General of MI5, said this: "I call it a crime. It's not an act of war. Terrorism is a violent tool used for political reasons to bring pressure on government by creating fear. In the same way, I never thought it helpful to refer to a war on terror any more than a war on drugs. For one thing, that legitimizes the terrorists as warriors. For another thing, terror is a technique, not a state, and terrorism will continue in some form, whatever the outcome, if there is one, of such a war. For me, what happened, referring back to 9/11, was a crime, and we need to think of it as such. What made it different from earlier attacks was its scale and audacity, not its nature." And so she agrees with really the legal profession here, and certainly the judges, that these are criminal acts to be tried in our criminal courts by the ordinary processes of jury trial and the ordinary rules of evidence and procedure. And what lay behind all those successful challenges, and what lies behind the application of the ordinary rules of evidence and procedure to terrorism cases, is the existence of the Human Rights Act. It has been a powerful barrier against encroachment into this area by politicians. And as you know, politicians are growing increasingly critical and vocal about the existence of the Human Rights Act, and you wonder why. And so it was that when the police investigated the background of the 4 dead bombers from the 7th of July, they discovered what they thought were co-conspirators in the plan. And those 4 co-conspirators, 4 young men from Beeston in Leeds, were charged and prosecuted in the ordinary way before an ordinary jury in an ordinary court in Kingston in South London. They weren't flown off to Algeria with a sack over their head to have their fingernails pulled out. They were charged with conspiracy to cause explosions on the basis of evidence that was fully disclosed to them, and they were given lawyers of their own choice, and very good ones, if I may say so myself. And they were tried by a jury in an ordinary criminal court, and that was a really important test of how robust our criminal justice system actually is. Because at the end of 2 3-month trials, a Kingston jury unanimously acquitted those 4 young men of having anything to do with 7/7, notwithstanding that the prosecution examination of their case and all the circumstances was rigorous. Not a stone was left unturned because of the importance of the case. But in the end, having tested the evidence, the jury acquitted them. And they were, as it happened, young Muslims from the same small area in Leeds as 3 of the bombers. They had known them all their lives. They'd been brought up cheek by jowl with them and their families. They'd gone to the same mosques and schools and gyms and so on. And they shared, to some extent, in their radicalisation, inspired by what they saw as the oppression of fellow Muslims in Palestine and Bosnia and Chechnya and other parts of the world. But importantly, they did not share the extreme views that eventually led the bombers to take a very different route from them. And when I look back on that case, I see it as a very powerful reminder of how robust our criminal justice system actually is when it's tested. And it continues to be up to the task because it's successfully, and by that I mean fairly and legitimately, tried and convicted a very large number of other people other wannabe bombers. For example, following in the footsteps of 7/7, it convicted the people in the Dirty Bomb case, and people who planned to make bombs out of fertilizer and plant them in London and around the country, the airlines plot to blow up planes flying out of Heathrow, the attack on Glasgow Airport, and only recently a plot to bomb the London Stock Exchange, all dealt with in the ordinary way by the criminal courts, with lawyers and juries and disclosure and transparency and fairness, and people convicted, and people charged pleading guilty because they see the weight of the evidence against them, and so they admit their guilt and they're dealt with robustly by the courts. And all of that represents to me, as a practicing lawyer, a vindication of the human rights jurisprudence that stands behind a commitment to due process, putting people on trial, telling them what the evidence is, proving their guilt if they're guilty, and punishing them appropriately. Now, that's not an approach followed by what might be described as our senior partners in the war on terror, the American government, notwithstanding a change of administration and the hope that many had that there would be some tidying up and some reflection upon past mistakes and so on, because arguably, although the American administration is more liberal, the position has not improved very much. In some ways, it's deteriorated, because Guantanamo remains open and trials in front of military tribunals are still on the agenda. Those seized in 2001, so now 11 years ago, never charged with any offence, rendered from Afghanistan and other parts of the world, remain in indefinite detention without trial. Yes, some of them have been repatriated. Many of them still remain. And a new and more sinister form of disposal is presently being practiced, because by executive order, targeted assassinations of the advocates of terrorism are being undertaken by the CIA, deploying unmanned drone attacks in foreign countries. They are simply killing their opponents. And there are many, many examples. Probably the most famous now is Anwar al-Awlaki, who was killed in such an attack in Yemen last October, along with some others who happened to be travelling with him. He was a firebrand preacher and a propagandist, a very successful propagandist of jihad. He justified the murder of civilians, and he supported ideologically attacks on the United States, including attacks on civilian targets. But he was an American citizen who had lived and worked and preached and been associated with academic institutions in America for many years before moving to the Yemen, where after several years, and only probably from 2008 onwards, took a much more radical political position and supported the sort of jihad which he did through his Inspire magazine. But he was an American citizen, out of range of the American courts, and so he was made subject to a death sentence. One cannot mince words about it. An executive order was passed by the president. There was no trial, there was no due process, and plainly there was no possibility of an appeal, and the CIA killed him. And this is all part of an expanding CIA-run program of targeted assassinations. We simply cannot ignore the fact that that is happening, however you may feel about it from a political perspective. Well, whatever we feel, it has given rise to a real storm of concern in America by human rights and lawyers' organizations. and not least because it's defended in precisely the same way and on the same grounds as all the things that went before it, Guantanamo and waterboarding and extraordinary rendition and sacks over the head and all of that kind of business. The victims of this are to be considered to be enemy combatants. They're not people who may be subjected to criminal charges. They are enemy combatants in the war against terror. So we don't have to worry about that. We can just kill them if we can manage to find out where we are. And that is a justifiable, non-legal, pragmatic approach, justified by the circumstances and the nature of the terrorist threat globally. Now, I don't know whether you buy that or not, but as a lawyer who spent many years working in the field, I find it sticks in the throat just a little bit. However, whatever you feel about these individuals and their political position and their dogma, do we pass an executive order to assassinate them? I don't know. Jamil Jaffer, who is, I think, the deputy president of the US Civil Liberties Union, said this: it is a mistake to invest the president, any president, with the unreviewable power to kill any American whom he deems to present a threat to the country. Vince Warren, another leading light, director of the Center for Constitutional Rights in America, said this: if we allow such gross overreaches of power to continue, we are setting the stage for increasing erosion of civil liberties and the rule of law. And you may think, I don't know, that there is some force in those simple and basic propositions. And our failure to identify this as non-legal execution, I find personally very disturbing, that we can't see it for what it is. And I am disturbed by the silence. I don't hear voices, political voices in this country speaking out against this growing practice. But then the drone attacks are in Pakistan, they're in the Yemen, they're not in Bradford and they're not in Salford. So we don't speak about it in the way that perhaps we should. What would we say as a community of the murder by bombing on a London street of Syrian dissidents ordered by President Assad, who considers them to be terrorists? People in this country who are seeking to organise funding and supply weaponry for insurgents in Syria fighting against the government. Would Assad be justified in passing an executive order to have them bombed on the streets of London? And if he did, what would we say of that, do you think, in fairness? Well, we would say it was murder, wouldn't we? Actually, you don't have to be a lawyer to work that one out. And what seems absolutely clear is that if the British Prime Minister gave such an order for the killing of a British citizen in similar circumstances, why he would be, he'd find himself in the dock at The Hague, and maybe there'd be a brief in it for me, I don't know. But there you are. What's disturbing is the justification behind all of this. It's the attempt to rationalise and intellectualise what's going on in a way which is provides a legal justification of sorts for the state to silence not only external but internal dissent, doesn't it? Once you go down that slippery slope, it's very difficult to crawl back up again. I think it's an extremely dangerous and disturbing road. And I say, on the contrary, there is a pressing need for states to see that human rights are not obstacles to security, but absolutely fundamental to it. Because if we abandon our own values, we reinforce the extremist narrative. We weaken our own conviction as to why we're fighting against it in the first place, and we lose. And perhaps I can offer a very simple, possibly simplistic view as to why human rights standards are not just of academic interest but are in the real world important. It's because they come into effect and they have real effect in the real world at times just like this, in times of political and social crisis, at times when it's all too easy for politicians to abandon, to cast aside the normal civilized standards and principles that govern our society and the rule of law we apply. The strength of a liberal democracy such as ours lies in its determination to deal with attacks upon it by abandoning neither democracy nor liberalism. And again, don't take that from me, Eliza Manningham Buller again, who says this: I'm often asked to speak at conferences and in debates on the subject of security versus liberty. I always refuse to do so because I don't see these as opposites. They're different, but there is no liberty without security. And she goes on then very eloquently to argue that the reverse is also true. There is no security without liberty, is the point she makes. And she says this: there is, of course, no such thing as 100% security. Life is full of risks. No government can guarantee its citizens' safety and should not suggest that it can. We in the UK have an expectation of not having to live under a cloud of fear from terrorist attack. We also assume, though, that we can speak our minds throughout our governments, live under the rule of law, have an independent judiciary and an accountable police force. We enjoy our civil liberties. We should not fear arbitrary arrest, and if we are accused of having broken the law, we expect proper and fair legal process. Now, what the Human Rights Act stands for is the universality of rights and freedoms, including fair trial and due process. And that means, by definition, they cannot be abandoned when the going gets tough and for reasons of political expedience. You can't have a prohibition against torture that you then circumvent without loss of all vestige of moral authority, in my view. And the terrorist who is not given a fair trial or is given no trial at all wins. It's as simple as that. And I have no sympathy, as you probably gathered, for the bomber or the perverse ideology or the corruption of religion that justifies atrocities. But we don't oppose the destruction of liberty and human rights by abandoning those things. And so for me, the rules have not and simply must not change. And this is not, I hesitated to say this in a room of academics, but this is no mere academic concern, because we now have a Justice and Security Green Paper presently under consideration by government, which reminds us of the need for eternal vigilance, because this is legislation which proposes to permit courts to try common law claims, so civil cases, using what's called a closed material procedure. We get to see the evidence, you don't, is what it boils down to. And it applies whenever a government minister, you'll hear some echoes now of things which have gone before as I describe this. These closed material procedures will apply whenever a government minister decides that disclosure of particular material would be damaging to national security. And the Green Paper is therefore designed to prevent, for example, the sort of material which has leaked out about British involvement in the rendition of people like Binyam Mohammed, who was plainly rendered, taken to a foreign country, treated very badly, and the evidence about complicity in that has managed to leak out. And this is the sort of measure which will prevent it happening in future. And it's dangerous because there is a very thin line between matters which are genuinely damaging to national security and matters which are merely embarrassing to national politicians. And the approach of government in this measure was described in a headline in The Observer last month as a betrayal of 800 years of British judgment, British justice. This is The Observer. This isn't the, copy of the Tribune or the Red Flag or anything. And Henry Porter, no doubt, no less, wrote this of this measure, which is, likely to come into force in the course of the next year. This measure is arguably more menacing to our legal traditions than anything dreamt up by, brackets, the Home Secretary's predecessor, Jack Straw, and the high commands of all the parties have read and apparently support the proposals that, in the case of the Liberal Democrats, amount to a historical betrayal of the principles of open justice. There is barely a whisper of opposition to the shoddy, self-serving and manifestly illiberal measures. So this is not an issue which has gone away, and as lawyers say in the movies, but not in real life, I therefore rest my case. I hope that some of those issues you'll find interesting. I'm very happy to answer questions or debate the issues with you. Please don't hesitate to tell me what you think. Thank you very much for listening patiently.